Hey everybody, Marc Victor here, and we're going to talk about guns today. So I am a criminal defense lawyer. I've been practicing about 27 years in the state of Arizona. I've also represented people in many other states as well. I represent people in federal court where I have represented people all across the country. And we've done many high-profile cases at our law firm. I am the person who founded the Attorneys for Freedom law firm. Every attorney at our firm is a pro-freedom attorney. Our firm is not left, is not right, is pro-freedom all the time on every issue. In fact, if you're not a pro-freedom attorney, you're not eligible to be hired as an attorney at the Attorneys for Freedom law firm. Makes sense, right? Okay, I also want to tell you first about this. This is the 5 things every responsible gun owner ought to know. If you're a gun owner, you should read this. It's available at Attorneys for Freedom. It's the 5 things that I think are most important for you to know if you carry a firearm. It's really a distillation of the questions that I've received speaking at gun shows over the last 25 or so years, speaking to groups of firearms owners, responsible gun owners, who are asking questions about carrying firearms. Also, I want to tell you that I am one of the founders of the new Live and Let Live movement. And the Live and Let Live movement hasn't yet kicked off. It will kick off in 2022, but you can find out about it pre-launch by going to liveandletlive.org. Why am I telling you about this? Because I want you to take a look at this. This is Live and Let Live applied to guns. Why is this important to you? Because this is, in my view, what our gun policy ought to be. Okay? So let me just say something right from the beginning. There are unreasonable people on both sides of this issue. And let me just break that out a little bit for you. The unreasonable people on the right, these are people who think that there should be no restrictions, no regulations whatsoever on anybody's right to keep and bear arms for any reason. Now, in my view, this is sort of a ridiculous position, right? This isn't a very well thought out position. For example, do you think that people who have been convicted of murder and sentenced to prison for, let's just say, 20 years or so, if they say, hey, I've got a right to keep and bear arms, and it says shall not be infringed, so there's no restrictions, I want to take my AR-15 to prison with me. Are you in favor of that? If you're not in favor of that, then you are in favor of some gun control legislation. There should be restrictions, right? I could give you another example if you want. Do you think an 8-year-old who stands up and says, I've got a right to keep and bear arms, or a mentally ill person, somebody who is severely mentally ill, who's not in contact with reality, if that person says, I've got a right to keep and bear arms, don't you think we should have some restrictions in those areas? That's why I've written Live and Let Live. What types of restrictions should we have? Well, restrictions that are consistent with what we call the Live and Let Live principle. What does that mean? It means you're in charge of yourself, right? Everybody should live and let live. When should the law get involved? Well, when you initiate force or fraud or coercion. Now, how does that apply to guns? Well, you can initiate force with a firearm, right? Think of an armed robbery or a murder with a firearm or an assault with a firearm. Of course, we should outlaw this, right? So if someone initiates force, fraud, or coercion with a firearm, we should definitely outlaw that. That's easy. But could there be a time when someone's mere possession of a firearm violates what I'm suggesting we should follow, the Live and Let Live rule? Yeah, there are some times, right? Say you have a long history of violating the rule, right? Say you are a convicted violent felon. You've been out doing drive-by shootings and things of this nature where you've been charged, given a fair trial, convicted, and punished. I think we have a right to say that you, by your mere possession of a firearm, create a substantial risk to another person, right? If you create a substantial risk to another person, that violates the rule, at least in my view, in the view of those who follow the live and let live movement. So we should ban you from having a firearm on that ground. We don't just get to take away guns because we don't like guns or something. If you don't like guns, don't buy one. That's easy. If you want to tell someone else they can't have a gun, that's a different question. Are they presenting a substantial risk? Well, if they're convicted violent felon, I think they do. But maybe there should be a process in place so they could petition the court and say, hey, that was 30 years ago. I'm not a violent felon anymore. Yes, I was convicted 30 years ago, but now I'm a responsible citizen. Okay, that's what courts are for, and that's what hearings are for. It seems like a reasonable way to deal with that problem. Then, of course, we've got competency questions. I've alluded to that already, right? If you're severely mentally ill, who gets to decide that, and what does that mean? Okay, we do that now. We have questions of competency now. We should do the same things we're doing. I'm sure this could be improved, and we should be arguing and changing legislation to more accurately get to people who really are lacking competency such that they can't have a firearm. Let's drill down on that. Reasonable minds can disagree, but we need to come up with a rational policy about people who are just not competent. And of course, this includes minors. Where exactly that line is, okay, reasonable minds can disagree here too, but I think most people would agree the 8-year-old doesn't get a firearm and the person severely mentally ill doesn't get a firearm. But like in the case of the violent felon, these too are disabilities that conceivably could be fixed, right? Someone may be deemed severely mentally ill today, but maybe down the road, after several years have passed and the person's received appropriate counseling or is even on the appropriate medication or whatever, that they're no longer a substantial risk. No problem there either. I think there's a third area also. You need to be safe with the firearm, right? You need to be a responsible gun owner, such that you are not presenting a substantial risk to another person. Same rule again, right? So if you don't know how to use the firearm, you have no idea how to store it safely, you don't know which end the round comes out, things like that, you create a substantial risk just by having a firearm. Can we fix this? Yeah, a little bit of education, learn about how to store it safely, keep it away from people who aren't competent. Look, if you're in that category, no problem with the firearm. As long as you don't present a substantial risk, then you should be able to do whatever you want with all of your property, which means your body, your property, personal property, your money, and your time. That's what freedom's about, folks. So to me, unreasonable people on the right who oppose all restrictions, no matter what, who view the Second Amendment as an absolute protection. I'm going to talk about the Heller case. Just to let you know, the Supreme Court doesn't agree with that position. They said right in the Heller case, there are reasonable restrictions. There are reasonable restrictions on all your freedoms, right? You can be put in jail. Your very liberty to move can be taken away under certain circumstances. So why should your right to keep and bear arms be any different? But also, to the unreasonable people on the left who don't want anybody to have guns because they don't like guns, who are you to tell a competent adult in a free country that they can't have a gun if they're not presenting a substantial risk, right? If they're actually safe with the firearm, you have no right to tell another person whether they can have a gun or not. If you don't like guns, that's fine. Don't have a gun. So, and we all need to recognize, just like the law against murder, no matter what law we make, people will break the law. No matter what laws we make to try to keep firearms out of the hands of dangerous people, we already know that they're going to break those laws and they're going to get guns, right? You can print a gun today. So almost anybody can get a gun. So we need to be reasonable in terms of our policy. We can't perfectly, just like we can't perfectly prevent all murders, doesn't mean we get rid of the law against murder, right? I think the same applies in the area of firearms. So I want to get that out of the way. I urge all of you to chart a reasonable course on firearms, right? Let's try to chart a course. If you're responsible, competent, adult, and you present no risk, substantial risk to another person by merely having a gun, what's the problem? Okay, so moving from that to gun law in America, and part of the reason why I'm so optimistic, we got to start with the Heller case back in 2008. Now, it's important to point out here that until Heller was decided in 2008, by the United States Supreme Court, there was a real question about what the Second Amendment meant at all. Yeah, not till 2008 did the United States Supreme Court finally straighten this out. Many people believed that the Second Amendment protected the rights of the states to have a National Guard or to have a militia or something along those lines. But people who actually look closer into the history and text of the Second Amendment recognize that the founding fathers of our country saw the militia not as the government, but it was the rights of the people. It was the people who formed the militia. But in any event, in 2008, in the Heller case, this came out of Washington, D.C., and the question was really, does the Second Amendment actually protect an individual's right to keep and bear arms at all? At all? Or is it just some collective right or the rights of a state? So Heller settled the question and said, look, the Second Amendment protects the rights of an individual to keep and bear arms, at least in the home. Okay, so they didn't reach the question about what happened outside of the home, and this is going to be important when we get to Young. But more importantly, I think the Supreme Court also made it very clear that the Second Amendment didn't originate your right to keep and bear arms. Like every other right in the Constitution, it simply enumerated rights that you already had, even without the writing of the Constitution. These rights exist prior to the drafting of the Second Amendment. This just puts down in words what your right to keep and bear arms already was. And also very important, in the Heller case, the Supreme Court settled really the purpose of the Second Amendment. And what they said there is, it's about self-defense. That's the reason you get to keep and bear arms, for self-defense. It's not because of any other reason. At least that's what the Supreme Court said. But very, very importantly, to my friends on the right who look at the clause and say, shall not be infringed, to read that to mean an absolute prohibition on any regulation, the Supreme Court in Heller also made very clear, like every other right, the right to keep and bear arms is subject to reasonable restrictions, reasonable regulations. And here's what they said. It doesn't apply to just any weapon, carried in any manner, carried for any purpose. That's not what the Second Amendment means as interpreted by the Heller case. They specifically carved out some exceptions. They said these aren't necessarily all the exceptions, but what's clear to them is if you're a felon, and again, I disagree with Heller a little bit here because I don't think any kind of felon should be prohibited. What if it's some kind of a theft or tax evasion or some other property type of a crime that has nothing to do with violence? I don't see any reason why there's a connection between that felony and losing your right to keep and bear arms. That's why I said at the beginning of this video, violent felons, those are the people who present substantial risks by simply having guns. Mentally ill, well, this of course makes sense, right? These are people who aren't competent, and the Supreme Court recognized in Heller this is a class of people that could be deprived the right to keep and bear arms. Also sensitive places. Maybe there are places like courthouses, certain power plants, things like that where the property owner, in this case maybe the government, but certainly in a private property setting, the property owner has every right to say, no guns allowed on my property. Let me pause on this for a moment, because I know that there are people who are very pro-gun watching this video, and I know because I've been speaking to this crowd for, like I said, about 25 years now, that there can be some confusion about property rights here. Look, if you're for freedom, you have to recognize the right of the property owner to make the rule under which someone can enter his or her property. Whether you like the wisdom of that person's rule is irrelevant. They don't need your permission. Same goes for masks, right? If you don't, the property owner has every right to say, if you want to enter my property, you have to wear a mask. Likewise, property owner also should have every right to say, no masks allowed on my property. The wisdom of the rule is for the property owner. That's what freedom is about, right? So by analogy, we can say the same thing about guns. If the property owner, which might be a homeowner or maybe a store owner, says, look, no guns allowed in my store or my home, if you're for freedom, you should respect the rights of the property owner. You don't have to go there. You can boycott, you can complain about it, but don't bring your gun and trespass on somebody's property if they've said no guns. We have a disagreement maybe about the wisdom of their rule, but you're not the property owner, so you don't get to make that decision. That's the downside of freedom. The world doesn't get to operate your way. People who own the property, their own bodies, their property, their money, their time, they get to decide how to use those things, not you. You get to decide that for your body, property, money, and time. Doesn't this make sense? And then also they said, the Supreme Court did in the Heller case in 2008, that there can be regulations on the commercial sale of firearms. That's what Heller said. So the pro-gun community who relies on Heller should also acknowledge that the Supreme Court was very clear in Heller saying that the government can regulate guns in these areas, and there may be other areas as well. They left that door open. Additionally, Heller Court said, the Supreme Court in Heller specifically said that the Second Amendment only applies to weapons that are currently in common use. That may be important at some point for somebody who wants to take some weapon that's not very common. Handguns, which was the issue in Heller, definitely common in use. The AR-15, where some anti-gun rights people call the assault weapon. Hey, by the way, a little footnote on that. Weapons don't assault people. People assault people. Sometimes people use weapons to assault people. Sometimes they use their fists. Sometimes they use cars. There's lots of things that can be used to commit an assault. But an assault is an act. A firearm is just a weapon. So there really is no such thing as an assault weapon. Any weapon, even this pencil or pen, could be used to assault another person. I think clarity on these issues is really important if we're going to have a civilized discussion, right? So let's focus on being reasonable and clear in terms of talking about the firearms issue. So that's what Heller had to say. But Heller, and of course this was 2008, when that was decided, like many of the rights in the Bill of Rights, the first 10 amendments to the Constitution, it's not so clear if these apply to only restrict the federal government or the states. And so we have something in our constitutional law jurisprudence called the incorporation doctrine. This is a way that the court can decide that certain rights are also applicable to the states. That's exactly what happened in the McDonald case. The Supreme Court decided that, hey, what we said in Heller, that applies to the states as well. But the Supreme Court really hasn't said very much about the Second Amendment since then. So we know what Heller said, we know what applies to the states, but we don't really know much more. Then we get to this big giant pig here. This is Young versus the state of Hawaii, and it's a heck of a read. And I got some notes here, I want to talk to you about it. First off, in my opinion, this case went completely the wrong way. In this case, so you know, Mr. Young, resident of Hawaii, applied to get a permission slip from the government, a permit if you will, to carry his firearm outside the home. In Hawaii, like they do in almost every case, said no, denied. So let's talk about what Hawaii's rule is. Hawaii says, look, if you want to open carry, you got to meet some requirements to get a permission slip from us. First off, you got to display or prove that you have some urgency to carry outside the home or some need to carry outside the home. All right, this is going to be probably difficult, right? You shouldn't, in my opinion, have to display some urgency or need to exercise a constitutional right, but that's what Hawaii said. Then you have to prove you're of good moral character. And then, finally, if you can prove all that, you still got to prove that you are engaged in the protection of life or property. Okay, so who does this apply to? Basically, security guards. So what Hawaii is saying is, look, you want to carry a firearm outside your home, you don't even talk to us unless you're a security guard. And then only in the active employment of engaged in your job, when you're acting as a security guard, sure, you can carry a firearm outside your home. But for everybody else, effectively, there's no right to carry a firearm outside of your home. That's where things stood for Mr. Young, who was denied the permit to carry his firearm. And basically he was denied on the prong of, look, you can't show us any urgency or any need for you to carry the firearm outside your home. Denied. So of course this went to federal court in Hawaii, and the federal district court in Hawaii sided with the state of Hawaii. This was then appealed to the Ninth Circuit Court of Appeals. This is a federal court, federal appellate court. Normally in the federal courts, when you bring an appeal, you get a 3-judge panel. And in this case, the 3-judge panel ruled for Mr. Young and said, look, the Second Amendment actually applies outside the home, because it doesn't just say the right to keep arms, it says the right to keep and to bear arms. They're using 2 different words. They should mean 2 different things. So to bear arms means to carry them. What does it mean to carry them? Are they talking about carrying them from the bedroom to the kitchen or something? No. This is about self-defense. Where do most self-defense problems happen? Sure, lots of them happen in the home, but lots of them happen outside the home too. So the 3-judge panel at the Ninth Circuit Court of Appeals ruled for Mr. Young. And then the Ninth Circuit decided to basically rehear the case and have a giant panel, I think of 12 judges from the Ninth Circuit, all sat to listen to rehear this case anew. And that's what produced the Young case. The question in that, really the sole question in the Young case, is the question of whether the Second Amendment right to keep and bear arms, whatever it is, does it apply outside the home, or is it just limited to the home? That was really the question. And what the Ninth Circuit panel looked at was just what Heller looked at, which was the historical traditions in our country, and even back in English common law. What were the traditions? What was traditionally looked at? And they looked and they said, you know what? Open carry outside the home, has historically been regulated. So what they did is, in my opinion, they used a very flawed test. They said, look, if there has been regulation of this right in the past, well, then it's not protected by the Second Amendment. So they went and did a very extensive historical review, and then they found, indeed, there have been some restrictions on the rights of people to carry outside the home. Therefore, no Second Amendment protection whatsoever. And that's really what they said. The test they used is said, number 1, does the law impinge on the Second Amendment? And to determine that, they looked at and said, the question should be, has there been regulation? And if there has been regulation, then yes, the Second Amendment doesn't even apply. They can regulate it. There's no protection at all. I don't like this test. If they found that, well, no, there's no regulation, well, then it's protected by the Second Amendment. And then, of course, this raises the question of what level of scrutiny should we use to look at this law to determine whether or not the Second Amendment is violated. A little footnote here. In my opinion, this level of scrutiny thing was a giant mistake from the very beginning. This is what happened back in 1937. I don't want to get too far off the track here, but in 1937, a lot of people don't know about this, so I want to drop a little footnote here. What happened was FDR was trying to pass his New Deal. All kinds of legislation coming through, which you might call various social programs. And the Supreme Court of the United States was doing what it does, was looking at these various pieces of legislation. In constitutional law, we call this the Lochner-era court, L-O-C-H-N-E-R. If you're interested, you can Google it and look it up. And basically what the court did was to say, look, there's a presumption of liberty, and if the state or the federal government does something that restricts that liberty, they got the burden of justifying what they did. If you want to impinge on somebody's liberty, you better prove it. And they looked at it and they struck down much of what FDR was doing. Well, this gets us to some issues that are present today, this issue of court packing. This is why we're talking about court packing. FDR then didn't like what the Supreme Court was doing, so he threatened to pack the court. In my opinion, this was one of the biggest flaws in our Constitution. Did you know the Constitution doesn't limit how many justices get to sit on the Supreme Court? There's currently 9. If there's no limit, well, heck, I could put another 10 on there and I can be in charge of the whole court. I'll just put 10 of my pals on the Supreme Court, right? As long as I can get them through the Senate, I've changed fundamentally the court. What's going to happen after that? Well, maybe the next president puts 20 on the Supreme Court. So obviously the Supreme Court saw this was a giant problem, and they didn't really have a very good defense. I wish they had brought a different defense and taken a different position and just sort of declared, you can't do that, it's unconstitutional, it violates due process or something like that. But instead, they said, look, FDR, you don't have to pack the court. Don't do that. We'll change how we do business. And they sort of birthed this level of scrutiny thing. And what they did is they made a division between important fundamental rights and then stuff they thought was less important, property rights and economic liberties. And what they said is, if the law impinges a fundamental individual right, okay, that's important. We'll look at it with something called strict scrutiny. We'll say to the government, look, you got to prove, you got to show a compelling interest. There's strict scrutiny here. This thing needs to be very, very narrowly tailored. But if it's just property rights or economic liberties, which by the way is virtually everything, because let me control property rights, you can have everything else, and what you'll find, I control everything. Property is everything. What's your property? Your body, your individual items of property, your money, that's all your property. Let me control that. I got everything, right? So what they said was, well, if it's only property rights that's being affected, we use something called minimum scrutiny. We accept everything that Congress or the legislature says as being true. Who are we to really check into it? And almost everything that is subjected to minimum scrutiny is found to be constitutional. They strike almost nothing down. So this was a huge mistake. That's why I pause on it, because the question here, back to the Young case, is even if this is protected by the Second Amendment, what level of scrutiny do we use? Do we use strict scrutiny, which means that the law likely will be found to be unconstitutional? Or do we use minimum scrutiny? In other words, the law will almost always be found to be constitutional. Well, it seems, and this is a part of our jurisprudence right now, that it's not very well settled, but coming out of the Heller case, what we have at the moment, from best I can tell, my read of the cases is, if the law impinges on what we call the core part of the Second Amendment, then it gets strict scrutiny. If it's not the core part of the Second Amendment, whatever that is, it gets a lower level of scrutiny, which has become more popular in the last several decades, which we now call intermediate level scrutiny. Maybe something closer to what the Lochner era court was doing for all, whether individual freedoms or property. And by the way, I'll just note, the Constitution makes no such distinction. The Constitution talks about life, liberty, property, all in one swoop. It doesn't say life and liberty, individual fundamental rights, and then the sort of red-headed stepchild of property rights. It treats them all the same, life, liberty, and property. You can find it in the Fifth Amendment and in the 14th Amendment. Take a look. They're all treated as equals. And that's the way, in my opinion, things should have been done. So anyways, they didn't have to reach that question, the majority in Young, because what they found was, because there historically has been regulation on the right to carry outside the home, the Second Amendment just doesn't apply. There's no Second Amendment protection, and they're off to the races, and they say the law stands. So that's what happened at the Ninth Circuit, and that's where we are right now. That's the law of the Ninth Circuit. Supreme Court hasn't spoken on this, but I want to say there was an excellent dissent, in my opinion, in the Young case. And I'm going to predict for you right now two things. Number one, this case is going to the United States Supreme Court. They're going to take this case, and they're going to analyze it. And then number two, they're going to side with the dissent, because the dissent has the better argument. Okay, so I want to turn to the dissent in the Young versus Hawaii case. These were the losers in the case, but they're going to prevail, in my opinion, at the Supreme Court. This is a very well-reasoned dissenting opinion. Basically, what they say is, look, this thing fails, Hawaii's law fails under any level of scrutiny, it doesn't matter. And the reason is because the majority finds that the Second Amendment doesn't mean what it says. It doesn't just say to keep arms, to keep them in your home. It says to keep and bear. Why would they say bear arms? They could have just stopped at keep, right? You have the right to keep arms. Instead, they said you have the right to keep and bear arms. And if you take a look at the definitions of bear, it means to carry. And they don't mean to carry from the bedroom to the kitchen here. They mean to carry them out in public. So really just the plain meaning the plain understanding, the common understanding of the text of the Second Amendment, if you just look at that, it's clear you get to carry outside. But what they said is the majority in Young effectively deletes the word bear from the Second Amendment. Doesn't make any sense. They said merely, and I think this is very important here, they make the observation that, look, merely because there is some historical evidence that there has been regulation of carrying firearms outside of the home doesn't mean that the Second Amendment doesn't apply. It's just absolutely insane to take that kind of a position. They showed that, they said that the majority absolutely proved that the manner in which a person is allowed to carry outside of the home, yeah, that's been subject to some historical regulation, probably as it should be, but that doesn't mean the Second Amendment has nothing to do with the situation. They find and they say that this is the core of the Second Amendment, and Hawaii absolutely destroys that right because you can't take it outside virtually at all. This takes an entire class. Everybody who's not a security guard engaged in the performance of their duties is totally prohibited from carrying a firearm outside their home. This, of course, severely burdens the Second Amendment if it doesn't completely abolish it altogether. And so they were in dissent. I found some interesting, as I was reading the case, some interesting quotes I wanted to read to you from the case. And this is from the dissent. For those of you who are interested and who are junkies like me, who actually want to read this thing, I'm reading from page 133. Quote, "Indeed, the Supreme Court in Heller was clear about what it means to bear," they put that in quotes, the word bear, "arms." And now they quote from Heller. "At the time of the founding, as now, to bear meant to carry," end quote. That's from the Heller decision. They then opine by saying that the Constitution delineates a specific right to carry a firearm as distinguished from the right to simply keep a firearm strongly implies the right to take one's firearm outside the home in which it is kept. This seems very obvious and logical to me. From page 134 of that decision, which the very next page, quoting from the dissent again, "Indeed, it would require a highly unnatural reading of the text to infer that the framers understood the Second Amendment to protect little more than carrying a gun from the bedroom to the kitchen in case a conflict arose along the way." Isn't that a great quote? That's in essence what the majority in Young thinks. From 135 of the dissent, they write, "But why bother clarifying the Second Amendment's application in particularly sensitive public places if it does not apply at all in any public place?" So what they're really saying is they're going back to Heller. And they're saying, hold on a second. The logic that you are using in the dissent, if there's any regulation, the second doesn't apply. In Heller, the majority specifically said, look, we can regulate your right to carry in lots of different categories, including sensitive places. That's outside the home. Why would the Heller court have said, hey, they can prohibit, the Second Amendment tolerates regulation of firearms in sensitive places, read outside the home, if there's no right to carry outside the home at all? This makes a lot of sense to me, and I think it's going to make a lot of sense to the United States Supreme Court, which, by the way, is far more, in my opinion, pro-gun now, switching out Justice Ginsburg and switching in Justice Barrett, far more now than when they made that statement in Heller. And then finally, on page 175, I'm going to read from the dissent here. This is the last little section I'm going to read. I thought this was a very interesting quote to include in the dissent. It says, quote, "The heart of the majority's argument is the proposition that the states, in place of the king, assumed primary responsibility for securing what was formerly known as, quote, the king's peace. The majority reasons that maintaining the king's peace was the king's duty, and in the English view, the carrying of weapons in public areas was an affront to the king's authority." Skipping a couple of lines, they then continue, What the majority overlooks is that our Constitution relocated the king's sovereignty not in American state or federal governments, but in, quote, we the people of the United States, right? So basically, look, we don't have to buy into the idea that it's the government's primary role to protect you. They're our agents. We're in charge of ourselves. We're Americans. The sovereignty that was afforded to the king is now ours. The government works for us. They're our agents. We have the right to defend ourselves. We have the right, subject to reasonable restrictions, of course, right? Assuming that you haven't shown by your past actions that you are a substantial risk to other people, the violent felon exception. Assuming that you don't present a substantial risk by having a firearm in your hand because you're not competent. Competency exceptions. Yeah, sure, we got to work all this stuff out, but this is what we lawyers do. This is what we litigate. And making sure that a gun in your hand is safe. You know where the safety is. You know what the trigger is. You know how to store it safely. Is this unreasonable? I think not. I think this, by the way, might be a different analysis for a handgun than as applied to some of the weapons I fired in the Marine Corps when I was in. Think belt-fed, 50 caliber, automatic, tripod-mounted machine guns. Do you think maybe we have some level of training, some competency to make sure you're safe with that weapon? Is that truly unreasonable? I think not. So again, let me finish where I started. We need to be reasonable about guns in America. Yes, there are problems. Yes, there's gun violence. We have lots of problems in America. But taking a position that nobody has a right to firearms isn't a rational position. It's not consistent with freedom. And taking a position that anybody can have anything that they want under any circumstance is also not a reasonable position. So join the discussion. Bring it civilized. Bring it reasonable. There's a way to chart a course here so reasonable, competent, safe adults can have firearms in America. That's what the Second Amendment's really about. So anyways, let me conclude by reminding you again, my name is Marc Victor. If you disagree with anything I said here, and how could you possibly disagree with anything I said here? But if you do, then feel free to reach out. I welcome especially people who disagree with me. Bring it civil. You will get a civilized response. The way to get a hold of me is just email me directly. It's Marc, M-A-R-C, at attorneysforfreedom.com. All spelled out. So it's attorneys and then F-O-R, not the number 4, freedom, hopefully you know how to spell freedom.com. That's the way to get a hold of me. Also, I mentioned the new Live and Let Live movement. I hope you check it out. I think it's the perfect time to start something new, right? If you're a Republican, you're probably cranky about how things are going with not just the Republican Party, but the whole country. If you're a Democrat, you're probably pretty cranky about how things are going with the Democrats and the country. Maybe it's time we close ranks and the reasonable people of the world recognize the rights of every person, every competent adult to both live and let live. We got to let live too, right? We got to be comfortable with the idea that other competent adults might choose to live their lives in ways we don't like. They may do things we find that are immoral or unhealthy or unwarranted or wrong. We can even try to talk them out of those things, no problem. But if you want a free country, if you care about freedom, the first place you should look is in the mirror. Are you the problem? Do you recognize the rights of your fellow competent adults to do things you totally disagree with? Sure, I already know you recognize the rights of other people to do the things you like to do. I get that. That's not impressive as a freedom person. But can you be a big boy and a big girl of the freedom crowd and recognize the rights of people to do things you totally disagree with, that you find completely unwarranted or immoral, so long as they're peaceful? If you're one of those people, I invite you to join the Live and Let Live movement. The last thing I'm going to say is tell you about the Attorneys on Retainer program. Are you a responsible gun owner who's worried that you might get charged with some kind of crazy felony just for simply carrying or maybe taking it out or making a bad decision in the split second, or maybe doing what you think is the right thing and having some prosecutor you think has a different view about things in the world, charge you with a serious crime. You should be. And if you're worried about that, I know your worries include, how much is it going to cost a lawyer to defend me? Do you know? For $25 a month, if you live in either Arizona or in Hawaii, you can have us on retainer. We are your lawyers. You are our client, and if you get charged with any of these specific gun crimes, and you can find them, just go to the attorneysforfreedom.com website. Up at the top, click on Attorneys on Retainer. It's colored in red, so you can't miss it. It'll tell you all about the self-protection option. If you live in any of the other 33 states that our program is available to you, you can get discounted legal fees. Yeah, we'll represent you countrywide. If you're in any of these 33 states, same thing, $25 a month. What do you get for a discount? It's a real discount, $175 an hour. No games, no mysteries, no weird small text or any of that. If you don't like the program, cancel anytime. We don't want you in it unless you want to be in the program. Really simple to understand. So I hope you check out Attorneys on Retainer. You can find it at the Attorneys for Freedom website. Again, my name is Marc Victor. Thanks for listening.